Hi there.
Hi, Leanne. How are you?
Good. How are you?
Very good.
That's good. So it seemed you had a busy day, I think, just like I did.
We both did, and I apologize to the viewers for us being late, but we're here and we're excited to share with you some of the news that we planned on sharing, as well as an example of collaboration of lawyers. Sometimes lawyers actually help out one another, and today, or actually a couple days ago, but today Leanne appeared for me in court on a case. It's never happened before. Is that right, Leanne?
That's right. This is the first time I've appeared as agent for Stephen Benmor.
That's right. So it was actually quite nice that I was able to reach out to you, and you were available and willing to help out, and you appeared for me today as a representative of me. And so, for the benefit of our viewers, this was an inaugural event.
Yep.
We collaborated, and I prepared materials, and you argued the case on my behalf in front of a judge. And for that, I thank you, Leanne.
Well, it was my pleasure, and I actually felt very honored, Steve, to be doing something on your behalf. So I was happy to be able to do it, and it was. I don't know. Should we tell viewers a little bit about it, or not?
Yeah, it's okay. We're not going to mention any names, but
Yep.
for sure. I had a situation where I represented a client, actually for the last about 3 or 4 years now, and I had agreed that my client would pay me for the work that I did when their home sold, which is not uncommon because a lot of people are house poor. They have a house, but really they don't have any funds. And then, of course, people don't have funds set aside for a divorce on top of everything else. So it's not uncommon for some lawyers to delay the collection of their fees until such time that the home sells and the monies are divided up between the two spouses. In my situation, I had a client that I represented quite favorably over the last few years. And then COVID came about 1.5 years ago, and she just went dark. And I didn't hear from her. And the difficulty of this situation is not that I was also not getting paid, but I had no client to get instructions from. I had nobody responding to my emails or my phone calls or my clerk's emails and phone calls. We tried everything. We even called and went through social media, called at work, left voicemail messages. This client just went totally dark. So then I brought a motion to have myself removed as lawyer, as well as what's called a motion for a charging order. So a charging order is basically a request that the home not be sold and liquidated without having my bill paid. And so the law says this: you are not allowed to argue a motion in front of a judge on your own affidavit, because I was the lawyer and I was asking for relief, i.e. to be removed as the lawyer for my former client and to get a charging order. I swore the affidavit that formed the basis of the request that we made to the court. As a result of me swearing the affidavit, which in effect means the evidence was in my name, I am therefore precluded from arguing the motion as the lawyer on my own affidavit. And so my associates were unavailable, and I turned to Leanne. And Leanne appeared today before the judge and argued my motion to be removed and for a charging order on my affidavit. So I'm a bit afraid to even ask the question: were you embarrassed on the materials that I prepared, or were they reasonably prepared?
They were impeccable. They were great materials, which made my job easier, because preparing good materials takes time, and I was in the fortunate position I just had to take materials that were really well prepared and just review them and make sure I was acquainted with them, and then go run with it and speak to it. So, you know, it was good to see. It's always interesting to see other lawyers, how they prepare things as well. Especially lawyers like yourself, who I respect. I'm always interested to see, you know, their affidavits or their motion material and factums and things like that. So it was good to be able to look through them. And as I say, I thought they were really, really well prepared.
You know, it's funny because you and I talked about this case today when you were done, and you reported to me on how well you did, and you did do well. One thing that you said, Leanne, and it made me reflect on it after the fact, lawyers, in one respect, it's an admirable profession. Society, members of the community have high regard for lawyers. Lawyers are also very philanthropic. Lawyers give a lot back to the community. But whenever a lawyer is pitted against another person, like a client, there always tends to be this sort of expectation that the lawyer is the funded, more powerful party, and the other person is the weaker party. And even though in this case, arguably, I was the weaker party, I was the one that wasn't paid, I was the one that could get a client to return my calls, your experience was different when you were before the court today. Why don't you share that with the viewers?
Yeah, I found right from the beginning, it was clear that the judge was sympathetic to the other party, who, you know, was a single mom, and she presented herself well and whatnot, and just, you know, by virtue of the fact that she was not a lawyer and she was there on her own, the judge was quite sympathetic to her and gave her lots of opportunity to speak, and actually had a lot more questions for me than for her, which, you know, I was interested in, because, you know, I felt that Steve's position and the position that I was arguing, you know, from a legal standpoint, was very strong. The materials were well prepared. The judge had said that he had read the materials, and it was clear from comments that he made that he had read the materials. So I was kind of expecting to be starting off in this situation where he was going to turn to her and be like, what's the problem, kind of thing. But instead, it was more like looking to me, why should I give you this? And he wanted me to really prove it, or prove, you know, argue the merits of it, rather than just accepting the well-drafted material that I was relying on. And he didn't really have questions for the other party. So that was interesting.
You know, and so the part of this that I reflected on after you and I spoke late this morning was the fact that in the materials, there were email communications between me and my former client. And when I wrote those emails, I was really writing them from a place of empathy. And so I wrote those emails because I always care about my clients, but in this case, I cared about my client. And even though she had not paid my bill, and even though she had not returned my phone calls and my emails for over a year, I still nonetheless felt sympathetic towards her. And so, and that was communicated in my emails to her, trying to resolve this without us having to go to court for a judge to deal with it. And the reason I mention this for the viewers is because a lot of people forget that communications can sometimes be looked at by other people. And sometimes people will say mean things, hurtful things, demanding things, maybe even be sarcastic in emails. And you never know who's going to read them. And so it is, the reason I say I was reflecting on it was because in as much as this judge today granted sympathy to the other person, I don't think he did anything wrong. But if he had read those emails and saw how hard I work to try to resolve this amicably out of court, he may have actually had a different view on the balance of power between me and the client, because I really did go out of my way to be empathetic and sympathetic and conciliatory with the client. And my takeaway to the viewers is really the golden rule. Treat your fellow person as you'd want to be treated. And even when there's conflict, it does not permit you to take a hard line or a mean-spirited approach. Always, always communicate with civility, with professionalism, with ethics in mind. For one reason, it's the right thing to do. For the second reason is you never know who's going to read it.
No, that's very true. And I mean, sometimes it can be hard. If you have a client that is, maybe being rude to you, or, I have cases where I'm dealing with self-represented people who at times can be incredibly rude to me. But I always have to take the higher ground and communicate politely, kindly, professionally. And part of that is because that's who I am. But the other part of it is because you don't know where that communication is going to end up. And it's always going to reflect well on me if I've, behaved politely and professionally when dealing with, anyone, whether it's a client or a self-represented person.
Another learning lesson for you and the viewers is, I'm not sure if you picked up on it, but those communications that I just described, those email communications in the weeks and months leading up to today's motion, included efforts on my part to try to resolve the issue today without going to court. Now, we as lawyers know that settlement communications are inadmissible in a hearing. And yet, in this case, the former client filed them as part of her affidavit in response to my motion. And yet, the judge did not strike them, did not exclude them, did not indicate that they should never have been filed. But I can assure you this, if we as lawyers filed those email communications that included settlement information, we would not have only suffered those being redacted or removed or struck out from the court file, we would have been scolded for having the guile to file inadmissible evidence. And so it just goes to show, on the subject of self-representation, despite what you might hear, there is a double standard.
Yeah, there is. And, I think on some level, as a self-represented person isn't going to know the law. Lawyers expect it to know the law and know the rules and all of that. But, sometimes I feel that, sometimes judges they bend over backwards to accommodate a self-represented person who is up against a lawyer. It might be different if you have two self-reps, but when they're up against a lawyer, because they know they don't have that same training and education, and so they're given a lot of leeway.
Right. What did we advertise we were going to share with our viewers today?
We advertised we were going to talk about the differences between a Section 30 assessment and a Voice of the Child report.
Well, for those viewers, we are going to follow up on our promises to you, and we're going to answer that in the remaining time. But if you have any questions about what we just covered or what we might cover, or anything that you think we should cover in the future, please put it into the chat, and we're all ears. But as advertised, we will be talking right now about the subject matter of assessments by experts to determine what a parenting schedule should be after a couple splits up. So let me introduce the topic and bounce it over to Leanne. So, people split up for a variety of reasons. Parents split up for a variety of reasons. In some cases, it's due to financial problems. In some cases, it's due to addictions. It could be personality disorders or mental health problems. It could be because of infidelity. The infidelity could be because it was a loveless relationship. There is a whole host of reasons, and if you have one, it doesn't mean you can't have another. And in some cases, people split up for a variety of reasons. One of the most complicated divorces, or the divorce types, is when people split up because the two of them have very different parenting philosophies, which cause them to therefore have tremendous parental conflict. and then they split up because of that. Sometimes it's fueled because of infidelity or financial problems or mental health problems or addictions. But in some cases, there may not be any of the others. It's just straight up, this is the way I want to be a parent, and that's the way you want to be a parent, and they just don't agree on anything. And so they fight, and then it eventually causes the relationship to end. Well, guess what? When the relationship ends, and they're still the parents of these children or child, it doesn't mean the conflict ends. And that is where we introduce this subject. So in Ontario, we've got a variety of tools in our toolbox to deal with the debate on what the parenting schedule, the decision-making authority over parenting, and the parenting guidelines ought to be. And so I'm going to throw out a few tools, and I'm going to let you, Leanne, define them for the viewers. Let's start with the cheapest one, asking a judge to order a government office called the Office of the Children's Lawyer to assign a social worker to do what's called a clinical investigation. On to you, Leanne.
So that's something that we commonly see done. What the biggest appeal of that for parents who are not agreeing on parenting issues with respect to their children is that, as Steve just mentioned, they don't have to pay for it. So we have something here in Ontario called the Ontario Children's Lawyer, and they get involved in certain cases. They don't get involved in all cases. So that's the one risk with that, is if that's something that people are relying on, the OCL, as we call it, may decline to take on a case. So there's no guarantee that they will accept a case. But if they do get involved, they have a lawyer who essentially provides a voice for the child or the children in the matter. And part of that lawyer's job, and they have access to, depending on what's going to be involved in preparing their report. Sometimes their report is more limited because of timing issues, and sometimes it's much more involved and could go on for, many months, if not longer. But during the course of their work, they meet with the children and more than once, and they meet with the parents, and they're there to ascertain, like, what do the children want to see happen? Who do the children want to spend? How do they want to spend their time? Do they want primary residence to be with one of their parents? What are the reasons for it? This sort of thing. And in order for the Ontario Children's Lawyer to work reasonably well, the children have to be of an age where, they're able to state some of this. I mean, obviously a 2-year-old isn't going to be the same as a 10-year-old about being able to, discuss their wishes and what they would like to see happen. But the children's lawyer is independent of the parents lawyer, and it is their job to provide a voice for the children when parents cannot agree on decision-making or a parenting schedule. And they prepare a report, and what they have to say is very highly regarded by the court. It's taken very seriously. If their findings go against what you as a parent would like to see happen, you are in a difficult position to get a judge to agree to something different. Their report their findings carry a lot of weight. But they can be very helpful in high conflict cases where parents can't agree on what is best for the children, and the children are caught in the middle.
Very good summary. A few things. One is the Office of the Children's Lawyer is a department of the Ministry of the Attorney General, and the office has two divisions, the estate side and the family law side. On the estate side, they get involved where a child is the beneficiary of monies from an estate where either the parents died, leaving the money to a child who's under the age of 18. They get involved in personal injury cases where the child is a plaintiff in the lawsuit and they need a judge to order an infant settlement. So that's the non-family law side. The family law side of it has lawyers and social workers. Many of them are not employed. They are called roster social workers or roster lawyers. For 8 years, I was a roster lawyer for the OCL. And Leanne, by the way, you would be a fantastic roster lawyer for children.
Well, thank you. It's
And
something I've
should you
considered,
have
so
a little bit
maybe I'll
extra
have to
time
apply.
in your busy schedule, do it. You know? So the OCL on the family law side, like I said, has lawyers and has social workers, whether they are employed in-house or they're on the roster side. And irrespective of that, the lawyers are assigned to cases in two situations. One, where there is a child involved in a CAS, Children's Aid Society case, a judge in the Ontario Court of Justice or in the Superior Court of Justice Family Division can order that the OCL assign a lawyer to a child who is the subject of a CAS proceeding. And in that situation, the referral is mandatory, which is another way of saying the OCL must assign a lawyer to a child involved in a CAS proceeding. And I did many of those in the years that I was on the OCL, where I got to put before the court the child's views on the CAS proceeding. In other words, should the child remain in foster care? Should the child be returned back to mom or dad or both? Or what are the limitations that should be put on? In the non-child welfare, non-CAS side, the OCL offers three things. One, you can have what you just described, Leanne, which is to have a social worker assigned to do usually what's a 30-hour clinical investigation that involves the interviews of the child, the parents, and any collateral sources like doctors, teachers, dentists, neighbors, family members, and then write a report recommending what the parenting schedule should be. And it's just a suggestion, it's not binding, but Leanne, you're 100% right. They tend to be given a lot of weight. The other one, which is much more popular these days, is to ask the OCL to provide what's called a voice of the child report, whereby the social worker is assigned to the child. There's no meetings or limited meetings with the parents. It's strictly to find out from the child or children what are their views and preferences with respect to what the parenting schedule should be. And the third one is where the child or children are assigned a lawyer, and the lawyer appears in court and acts as the lawyer or legal representative for the children and does not state what the children want or what the children state their views are. The lawyer in that situation states what their position is on behalf of the child. It's somewhat of a distinction without a difference, but the lawyer does not give evidence. The lawyer simply parrots the position of the child, which sometimes matches the position taken by one of the parents, or in some cases is an alternative position to the position that the parents take. And those are the different things that are available. About 3 to 4 out of every 10 cases that judges refer to the OCL are accepted, which basically means somewhere between 60 to 70% of cases are declined by the OCL because it's a public service. It's not available to anybody that wants it. So the OCL has an intake department that screens out cases that they don't take on. So now back to you, Leanne. For people that are not going to go the route of the OCL, or they tried the OCL and they didn't get in, they can go the private route. And that is called a Section 30 assessment. And that's Section 30 of the Children's Law Reform Act. So Leanne, tell us a little bit about that. What does that look like?
And just before I elaborate on that, they can also get a voice of the child report privately as well. That is an option where they can hire, there's often people out there, social workers, mediators, who are properly trained in providing voice of the child reports, and lawyers too. And so they can go the private route with that if they get rejected by the OCL. In terms of Section 30 assessments, they are much different. They're much more involved, much more costly because of that, and because they are done privately. They can range anywhere from 12,000 to 30,000. I mean, they can be very expensive. So unfortunately, sometimes that can be an issue for parents if they're not in a position where they can afford something like that. It can be a problem, or sometimes they argue over who's going to pay for it. But that's another topic. But in terms of what a Section 30 assessment is it involves a very extensive evaluation by properly trained psychologists. There's particular ones who specialize, in this type of thing, in doing these types of assessments. And they meet, they do a lot of work. They do a lot of interviews with the children. They meet with the parents multiple times. They meet with teachers. Or speak with teachers. They other collateral, whether if the children are in therapy, they would speak to children's therapists. They might speak to parents' therapists. That it's a very, very extensive procedure that's done, and it's designed to assess, and I'm going to use the words, the custody and access, but that's really the parenting decision and parenting schedule of the children, where parents, cannot agree. So this assessor is going to meet with all these people. They're going to meet multiple times over a period of time, and they're going to come out with a set of recommendations as to what they think would be, in their professional opinion, the ideal arrangement for the decision making and the parenting schedule. So unlike the OCL or Voice of the Child report that really is just, providing the children's views, not the OCL's views, and not the person doing a Voice of the Child report's views, the assessor is trained in this area, and they provide his or her recommendations as to what they think the parenting schedule and decision-making arrangement should look like. So that's the
so for those viewers that are wondering, well, I was, or I am, or I will be involved in a divorce that involves very diametrically opposed views on parenting. Is this right for me? And the answer is maybe, and that's precisely why we exist. We lawyers will look at a set of facts and give advice and an opinion, not only on the law, but upon the tools that are available to be able to achieve a amicable, immediate, and inexpensive resolution. And the subject matter of parental disputes is a live and extremely important issue. Some people will say, I'm not going to spend $50,000 to value a car that is worth $30,000. That's a very reasonable economic decision. Some people will say, I'm not going to spend $30,000 to appraise an asset that is worth $15,000. Also a very reasonable conclusion. But some people will spend $50,000 to advance a assessment over their children, because there is no price tag on the importance and the concerns regarding kids. Now, with that said, after being in this business for just under 30 years, I can tell you where I have found these private assessments, albeit very expensive, to be worth the money, and I'll tell you where it was not worth the money. So where was it worth the money? In cases where there has been drug addictions or alcoholism, in cases where there have been allegations of sexual impropriety involving minors, sometimes the subject minors, sometimes minors that are not part of the family, for example, nephews and nieces. In cases where there has been criminal activity that might directly place the child or children at risk, and there's a question as to whether the children should be allowed to have unsupervised contact with a parent. In those cases, the value add of an assessment is significant because it does two things. One, it x-rays the problem. It does not allow the problem to be buried under the rug. That's number one. Number two, oftentimes the assessor will provide recommendations for therapeutic interventions should they be appropriate. And if they're not appropriate, the assessor will indicate why those allegations have been carefully examined and put to rest. And that is absolutely critical, because nobody wants allegations about impropriety regarding parenting to be that black cloud that hangs over a head for either side, the person making the allegation or the person who is alleged to have done something wrong. And in those situations, $10, $20, $30,000 later, as big as a bill that is, it's money well spent to be able to move forward, especially for parents that broke up as a result of parental disputes. The cases where it has not been particularly valuable is where the actual claims being made don't arrive at the level of being clinical. So for example, parents dispute over, whether it should be one overnight or two overnights a week, whether it should be a pickup or a drop off on Sunday night or Monday morning, whether they should have the ability to travel with the kids every summer for 2 weeks as opposed to 1 week. That's not money well spent. The money in that situation is better spent in mediation with a very good mediator. So let me ask you, Leanne, what do you find between these two tools? Have you had any experience with using the Section 112 from the OCL or the Section 30 from the OCL versus Section 30 from the CLRA, I should say?
Yeah, I found all of them to be helpful. I have had a case where I had a client in the OCL made findings that were not what my client wanted. And so, in that standpoint, she was in a difficult position, and it affected the advice that I gave her. And I've had other cases where, when I was trying to, I wanted my client, or my advice, my professional opinion for my client was that they agreed to a certain course of action with respect to the children, and they weren't agreeing. And then an OCL report came out, and it gave me the extra thing I needed to convince them that this was really what was best for their children. I have had cases also with Section 30 assessments, and I find they can be quite helpful. One area that you didn't touch upon where I have found them helpful is in parental alienation cases. I have found that in situations where that has gone on, a properly trained psychologist can sometimes get to the bottom of whether, because that's an allegation that gets thrown around a lot, sometimes properly and sometimes improperly. And so, with a full assessment under Section 30 of the Children's Law Reform Act, a psychologist can sometimes get to the bottom of whether that has gone on and how that's affecting the children, and what the best course of action is in terms of should, there be a reversal in, the decision making and the parenting time because, against the alienating parent, or is that going to be too detrimental to the children and they need to stay where they are, even though this parent may have shown alienating tendencies, or whether, again, where that accusation is being made and it's not proper, and it's like the Section 30 assessment is able to come out and say, look, that's not what's happening here. And it can help shut down that argument where it's being made. So I have found them, in addition to the types of cases you mentioned, I have found them helpful in those cases as well.
I have way too much to say about parental alienation and the role of either the OCL or a psychologist, psychiatrist, or social worker dealing with alienation cases. And I think what we're going to do is we're going to have a really healthy discussion, possibly debate, on the role of a Section 30 assessment on another day. But
sounds good.
Suffice it to say, for those that don't know this, a OCL involvement, from the minute that you mention the OCL to the completion of the report, could easily be between 4 and 6 months. For a Section 30, it's about double that. Sometimes a little bit less, sometimes a little bit more. But if we get hired today on a case involving parental alienation. First, we have to have pleadings. Then we have to have a case conference. Then we have to have a motion. And then we hire the assessor. And then 6 months later, we might get a disclosure meeting. And 9 months later, we might get the report. The reason that's relevant is because if the alienation is occurring, it's occurring for a really long time. And I have found in my early years that alienation cases in Section 30s had a really good role, just like you said, Leanne. And I find that in my later years, cases like that require immediate intervention in court to stop the alienating behavior, whereas going the route of a Section 30 will allow the alienation to continue. So it may be that they should both occur, i.e., hard, immediate, and aggressive court intervention coupled with the Section 30 analysis. But in some cases, it's just, if we get in there and get in there fast, it's better than the actual assessment, because the alienation is another way of saying damage. Alienation is damaging a child. It's not just damaging the relationship between a parent and a child. It's damaging the child. And to go and study it for a year is watching the damage continue. And so, anyway, that's my prelude to the later, longer debate that we have on the role of the Section 30 assessment with alienation cases. But I think we did a fairly good job, at least introducing the two tools.
I think so. I think it was a good summary for people to get a basic understanding of what's involved. So hopefully all of our listeners found it really helpful.
Excellent. And thank you again, Leanne, for today and earlier today and for this today.
Thanks, Steve. See you again next week.
You got it. Bye, everybody.
Bye. Bye, everyone.